Hello, friends. I am Navi, back to discuss some of my thoughts on data protection. Now, wanted to just bring to the attention of people two specific cases. One is the case of a fine which was imposed some time back on a data processor in Sweden. This is the case of Voice Integrate, who was fined by the Sweden authority for having failed to have adequate security measures for keeping the recorded voices. This was related to a medical consultancy service run by Sweden, in which a company called MedHealth was the main contractor, the data controller. They had outsourced their work to a Thai company called Medicon, and both of them were actually depending on the technology services of Voice Integrate for recording the public phone calls which were received and for which perhaps the medical people gave their suggestions. Now, what we need to remember in this particular case is that when the penalty was imposed because the recorded information was not properly secured and it became public, this MedHealth, which was a Sweden company, was fined about 1.2 million euros for their negligence as a data controller. And the Voice Integrate, who was a data processor technology service provider, was fined about 24,000 or nearly 25,000 euros for their part in the negligence. But in between, the Thai company was not fined because it was a data processor which was not within the jurisdiction of Sweden. So that is one thing which we may take a note, that a data processor who is not in the jurisdiction of the EU country may not directly be fined by the supervisory authority. It does not mean that they will escape financial penalty because the contract between them and the data controller would have included perhaps an indemnity clause, and they may still be liable for whatever is their liability. So this is one important aspect we must remember, that the jurisdiction of the supervisory authority is restricted to companies which are within the jurisdiction of the supervisory authority and not others. Others will have to be held liable only in case the contract has such a provision, and the liability will be contractual between the data controller and the data processor. So this is one aspect I would like people to remember. There was another case which I wanted people to remember. This was the case of the Kyoto, which was an Italian case involving the employees. The problem here was that an outgoing employee which had left the organization wanted to exercise his right of access to some information, his personal information, which was with the company. How did his personal information came to the company was because as an employee, he was allocated a particular PC, and he was also allocated an email which he was managing, and that email was not a personal email, it was a email customer service at kyoto.com or whatever is that. But this person, this employee, was using this company provided PC for his personal use, and therefore some photographs, other personal information he had stored there. And this email, which was customer service at the name of the company, was also being used by him for certain personal communication. Therefore, certain personal information was contained in this email also. So he wanted to take out those information and also delete that information further from the custody of the company. Now the company was not clear about what it has to do, because they were dealing with a corporate asset which was actually misused by the employee for personal reasons, and whether the rights have to be extended for the misuse of the device was definitely a question which had to be checked. And in fact, some of the things which the company wanted to look at was the websites which he was visiting, and they would analyze and look at what kind of websites the employee was normally visiting. Now, this kind of analysis is done because every employer wants to know about the employee's say working profile. So this question has thrown up, this particular case has thrown up the responsibilities of the employees in using the assigned corporate assets. Now, for whatever reason, this Data Protection Authority of Italy actually fined the company, though in nominal terms you can say 10,000 euros, for having not obtained proper consent, indicating or proper informed consent, leaving the employee to think that he could use this personal, this device or the email for storing his personal data, or for the company refusing to provide that information. So this decision appears slightly, in a way, strange, because for a person who commits indiscretion in terms of employment conditions and uses the data, uses the device, one thing is to say that, okay, it's personal data, if he wants to take it back, let him take it back, and also perhaps agree to his request for erasure. But finding the organization, however small it is something which is difficult to understand. So companies will keep on worrying about the status of the consent with their employees. Some of these supervisory authorities are so strict in interpreting the undue influence clause of a contract, saying that between an employer and the employee, always there is a undue influence being in operation. So you can never get a free consent from an employee, which may be true to some extent, but one also has to look at if you cannot get the free consent, then does it mean that the employee is always at an advantage to take advantage of all the employment benefits, and then when he is not employed, try to object to why my personal information was processed in a particular way? That would be an unfair advantage for employees, which cannot be accepted as a fair law. So what this Italian supervisory authorities decision indicates is that the supervisory authorities need to also look into the aspect that data protection law is not meant to treat the data processor or data controller as if he is an enemy of every data subject, and whatever he does is done because he wants to create harm. See, at least Indian law is very clear that you have to actually show me what kind of harm has been caused to the employee by a certain processing. Now, if there is no harm, it's only a matter of principle that, there is a data protection principle which has been perhaps slightly uh, overridden or something like that with legitimate interest. The question of how much of legitimate interest is valid or not is always a debatable point. Nevertheless, um, it is now a matter of fact that at least there is one supervisory authority who thinks free consent cannot be obtained from the employee, and the use of assets given to him, if it is used personally also, you cannot question the person. Now, as a company, what should I do now? Now, I have to ensure how do I prevent an employee from misusing the corporate assets and still claim it as a matter of right. So there are two ways of looking at these things. One is, if you are entering into an employment agreement, and if consent is to avoid the undue influence, then the only other way is to bring in a third-party witness to the employment contract to say that these are the terms of my contract, and the employee is made aware in the presence of this witness to actually follow certain employment norms. And secondly, whenever a person is allocated an asset, including a special email ID at the company's name, or a, let us say, work from home permission, then we have to enter into another contract with the person, again witnessed by a third party, saying that this contract is beyond undue influence charge. We have explained everything, and the person has fully understood what he is agreeing to, and he is agreeing that he will not misuse the company email for personal email and device for his personal use. And in the event that accidentally such use happens, he will first of all delete such information, and he will indemnify the company for the consequences of him transgressing the particular law or the rule of employment. So I think this is something which the employers should keep in mind. And in case any of you have got any counter opinions, you are welcome to actually get in touch with me, either comment here. But in order to discuss certain issues like this in future, if you would like to follow this channel, I would be quite happy. And give me some say questions. We will try to debate that. Thereby, mutually, we will be able to enhance our knowledge. Thank you. We will see again soon.